This share isn't about what's wrong or right. It's about having critical thought. It's about not being reckless, not sharing cowboy information. It's about doing our own due diligence. And it's about maybe picking our battles and sifting through what really works in the real world and not just in theory. It doesn't hurt just to ask questions and then dive deeper down the rabbit hole. Comprehending the use and point of fiduciary letters, false notices, and their consequences. So I've seen so many amazing humans explore the practice of sending fiduciary letters and notices to public servants and the like, but without a specific incident or clear purpose, as well as, maybe miscomprehending the potential implications of such actions. It is important to carefully consider both the lawful effectiveness of such notices and maybe the potential risks involved. Do public servants owe fiduciary duties to individuals? Public officials are generally considered fiduciaries to the public as a whole, meaning they must act in the best interests of society rather than individuals. However, this fiduciary duty does not typically extend to personal relationships with individuals and personal direct connections individual to individual. So, could sending fiduciary letters to public servants without a specific legal incident or valid contractual relationship align with legal standards? What's the point of throwing mud at a wall or laying out a complete blanket over everybody? Since fiduciary obligations arise from established roles, such as trustees, legal or lawful representatives, or financial custodians, a general fiduciary claim against public servants may not be recognised in law. How might the perceived authorities see unsolicited legal notices lacking a clear legal basis? When one sends legal notices that lack a clear and enforceable legal basis, authorities may interpret such actions as frivolous, misleading, or even harassing. Could such blanket letters be viewed as an attempt to disrupt or intimidate said public officials? If notices contain demands that have no lawful authority, they may just be ignored, or worse, escalate into legal consequences for the sender. Now, I'm not saying that would happen, I'm just putting it out there. Could repeated submission of such notices lead to mental health evaluations? Some jurisdictions use mental health laws to assess individuals whose actions persistently disrupt legal processes or indicate, in their perspective, irrational behaviour. Could repeated submission of unfounded claims raise concerns about one's mental well-being? If authorities misinterpret the intent, and I'm sure the intent is well-meaning, they might initiate actions under mental health legislation. For example, in Queensland, Mental Health Act 2016, which allows interventions if someone is perceived as a risk to themselves or others. And what are the risks of being designated a vexatious litigant, whether they're right or wrong? Individuals who frequently submit legal documents without merit risk being classified as vexatious litigants. This means that they may be restricted from filing future legal actions, preventing access to the courts even for legitimate concerns. And I'm going to go over that again. I think it's really important that if you are here to do good, I think having the strategic plan before throwing mud at the wall is really, really important. So how does one ensure they are using lawful, effective methods to address grievances rather than strategies that could cause legal restrictions? What are appropriate channels for addressing grievances with public servants? And again, I'm not saying what are, what aren't. I'm literally just speaking out loud so that we can find remedy. And trust me, I know that a lot of the formal traditional processes don't always find remedy. Because in the traditional sphere, if there are concerns about public servant misconduct, things like filing a formal complaint through the relevant government agency, using administrative review procedures where available, or seeking lawful remedy through established legal avenues rather than unofficial declarations. However, we know there's so much corruption. So how do we know if even those pathways will even work? I feel our collective frustration. The danger of false notices and misleading documents. And look, I'm not the only one. We see daily from humans that mean really well, sharing images on social media of documents that are just farcical, right? And so, yes, false notices that claim legal authority without valid enforcement can cause confusion, harm credibility, and even lead to legal consequences. Why do such notices hold no lawful weight? Number 1, lack of official authority. Documents claiming to be issued by the US military or military intelligence in a legal enforcement capacity do not follow recognized legal procedures. The reference to a US Supreme Court of Justice, well, it's just incorrect because no such entity exists, and the actual US Supreme Court does not issue high court warrants. Number 2, misuse of terminology. The claim that all current laws are dissolved is factually incorrect. Laws can only be changed through the legislative processes, not unilateral declarations. Military law cannot simply become active over civilian governments without an extreme national event. Now, again, we could go down that rabbit hole, and we've seen it happen time and time again, but that's for another day. Number 3, false claims of enforcement. For example, I'm not saying if this is right or wrong. Interpol does not have operational police powers. It is an information sharing organisation, not a global law enforcement body. No global police force exists that enforces unilateral declarations from unknown entities. Number 4, misleading references to historical documents. Citing Article 61 of the Magna Carta is a common tactic in legal misinformation, but it does not carry enforceable authority today. Again, I'm not saying I'm disagreeing with Article 61. I'm just talking about the practicalities in the modern sphere that we're in. Common law does not override modern statutory law in most cases, but both coexist in the legal system. Number 5, use of official-looking symbols. The presence of seals and logos does not indicate lawful legitimacy of a document. Government or military documents follow strict legal formatting and official communication channels. So, final thoughts on this matter. The risks of sharing misleading notices. Documents mixing real legal terminology with incorrect claims can be confusing and create false beliefs about how the law operates. Sharing or relying on such documents could result in trouble, including being flagged as vexatious, litigant, or facing allegations of fraudulent misrepresentation. It is always best to verify claims and documents. Just do your due diligence. Don't just double check, but triple check everything before you share it across social media. Maybe, would a more strategic, lawful approach to holding public officials accountable be more effective in the long term? Now let's look at the document that I'm sharing in this particular post. And I'm not making any claims, I'm just allowing space for critical thinking and asking questions. So when looking at this document that's been shared across social media, in real life, presenting this document in a mainstream court and saying those words out loud, whether a magistrate's court, district court, or any other statutory court, I'm just putting the question out there. Could it result in the following outcomes? Would the court dismiss it as being legally invalid? Mainstream courts operate under statutory law, and judges and magistrates will not acknowledge documents referencing common law courts or claims of military law being active unless officially enacted by a recognised authority. The claim that all current laws are non-void and dissolved would be outright rejected in a mainstream court because legal systems continue to function under statutory law. Would there be a risk of being ignored, laughed off, or held in contempt? Maybe, Most magistrates and judges would either ignore the document or dismiss it outright as having no bearing. If you persisted in trying to instruct the judge or magistrate based on this notice, you may be warned for contempt of court, meaning the judge could fine you or order your removal from the courtroom. Misuse of military and judicial terms. This particular, I guess we call it a document, more like a photoshopped image, references the US Supreme Court of Justice, which does not exist. The US has a Supreme Court, but no Supreme Court of Justice. Military law only applies to military personnel unless a state of martial law is declared, something that cannot be declared through an unofficial notice. Interpol does not enforce local laws. They are an international policing organisation dealing with cross-border crimes. Now, what happens if you instruct the judge or magistrate? If a judge magistrate gives you the opportunity to speak and you attempt to instruct them using the words on this document, they may ask you for legal authority behind your claim. He who makes claim bears burden of proof. They may tell you to proceed with recognised legal arguments, for example, citing actual case law, legislation, or established legal principles. Now, you might be able to do that. If you insist on your position based on this particular wording of the document, they may either dismiss your argument entirely or hold you in contempt. So what do we do instead? Look, I'm not saying that one should do this, but if you wish to challenge statutory authority in a lawful manner, use actual recognised principles, challenging jurisdiction with established case law. Maybe you could invoke common law in a way that aligns with existing precedents, rather than blanket claims about military law or dissolved statutes. You could demand proof of jurisdiction properly, asking the court to demonstrate how they derive authority over you, rather than making unsubstantiated claims. Just something to think about. We are all just learning, and there's more than one way to skin a cat. And there are some amazing living men and women testing, trying, and for that, I think we should be commended. We just need to think strategically and realistically on what is actually going to work. And we don't want to be doing black belt karate and only wearing a white belt, so to speak.